What types of protective orders can you file in family law? Imagine a situation where someone feels unsafe or threatened in their own home or family. Knowing your options for protection can make a big difference. Today, we're going to look at the different types of protective orders you can file in family law to keep yourself safe. First, there is the Emergency Protective Order. This is a quick, short-term order issued usually within hours after law enforcement reports domestic violence. It lasts about 72 hours and is meant to give immediate safety. It can be issued without the other person being present, called ex parte, which means the abuser might not even know about it right away. Next, there is the Preliminary Protective Order. This comes after the emergency order and lasts up to 15 days. It is granted by a judge if there is enough evidence that abuse or threats happened recently. During this time, a full court hearing is scheduled where both sides can speak. The respondent, or the person the order is against, has the right to be heard at this hearing. Then, there is the Longer-Term Protective Order, sometimes called a 2-year order. This is issued after a full court hearing where the judge finds enough proof that abuse or threats occurred. These orders are not always permanent but last for a fixed period, like 2 years, and can be renewed. They prevent the abuser from contacting or approaching the victim and may include other restrictions like stay-away zones. Another type is the No Contact Order. This is often used after criminal charges are filed for domestic violence. It bans any contact, including through third parties or electronic messages. It can also restrict the abuser from being near the victim's home, workplace, or other places they visit regularly. Sometimes, additional conditions are added, like counseling or giving up shared property. There is also the Anti-Harassment Order. This order stops harassment, threats, or intimidation that cause fear or annoyance. It does not requiring a specific relationship between the parties and can be used when someone repeatedly causes distress, whether inside or outside of family relationships. Family abuse protective orders are specifically for family or household members. They stop violent behavior, threats, stalking, or controlling actions by current or former partners, children, or relatives. The person requesting the order must have a qualifying relationship with the respondent. Lastly, there is the Vulnerable Adult Protection Order. This order protects adults who are at risk because of age, disability, or mental capacity. It can be filed by a guardian, family member, or authorized person to stop abuse, neglect, or exploitation. It covers threats, physical harm, financial abuse, or abandonment involving adults who are part of the family or household. Filing for these protective orders is a key step in family law to keep victims safe. They can influence custody and visitation arrangements and help create a safer environment for everyone involved. When you file, you need to show evidence of abuse or threats, and a court hearing will decide whether to grant the order. These orders can include no contact provisions, stay-away zones, or counseling requirements, all aimed at protecting victims and their families. Remember, the petitioner is the person asking for the order, and the respondent is the one it's filed against. An ex parte order is issued without the respondent being present, usually in urgent situations. The standard of proof in civil cases like this is called preponderance of the evidence, meaning it is more likely than not that the abuse or threats happened. Knowing your options can help you take the right steps to stay safe. Whether it's a short emergency order or a longer-term protective order, each one plays a vital role in addressing domestic violence and family safety issues.